Good morning. I hope everyone had a great Thanksgiving holiday, lots of food, great family and friends, and calorie-free.
We'll take the floor.
Yeah, exactly. We could, look, a majority of it is good, right? All right, so we have three cases on the docket today. Only one is scheduled to argue. The other two have submitted on the briefs. And so, of course, you have the one that's scheduled to argue. So case number C240247, Deetra Butcher versus John Butcher. If you can please identify yourselves and your readiness to proceed.
Yes. My name is Karen Meyer, and I'm the attorney representing John Butcher, who is the appellant defendant in this case. He's not ready to proceed.
Thank you.
Kathy Cook, Rapoli, Peter Butcher, ready to proceed.
Thank you. Then the other two we have are submitted. The cases, so first one is case number C240182, GH Building LLC versus Andrew Breving. And the third one is C240122, Bridgeport Investments LLC versus Stephen Souders. All righty. So counsel? Good morning again, Attorney Myers.
Good morning, thank you.
Meyer, that is, and you want to reserve time?
I do, for 2 minutes.
2 minutes, all right. Whenever you're ready, you can
Thank you.
start.
May it please the court, as I'm sure the panel is aware, this is a case regarding post-decree spousal support, and more specifically, whether or not my client, John Butcher's obligation to pay spousal support to his wife, ex-wife, Deetra Butcher, should continue based upon the terms and conditions of the party's decree, which requires, among other things, that the spousal support obligation of John Butcher be terminated upon a showing of Deetra Butcher's cohabitation in a marriage-like relationship. In this case, Mr. Butcher presented evidence showing that back in May of 2020, Deetra Butcher.
And I guess I want to ask you a threshold question, which is, I understand the evidence that was presented, and that evidence might have persuaded me had I been the trial judge. But from our vantage point as the Court of Appeals, we have to look at this as a manifest weight question. And so, you presented evidence that I would view as circumstantial evidence of cohabitation, but that was ultimately rejected by the trial court. And so what do we do with the trial court's rejection of that from a factual perspective?
Well, our position is, as the court's indicated, is that the trial court's rejection was error, was wrong. It was incorrect. It was against the manifest weight of the evidence. As the court indicated, we went through all of the factors that the trial court actually applied based upon the case law and based upon the factors laid out by the case law as to how to determine cohabitation. We went through each of those in each of the cases that the court had utilized, showed each of the factors, and believe that the conclusion that the court drew in basically saying, yes, you determined each and every one of these factors, however, we're not going to find that that rises to the level of cohabitation based upon this case law, was absolutely against the manifest weight of the evidence. And they failed to use some of the factors that we had.
Well, as I look at these factors, like the case law seems a little bit inconsistent in like what tests we're supposed to be applying. So how would you articulate the test?
Well, I think the test, if you will, was laid out on page 7 of the trial court's decision. It was the conclusions of law. And on page 7 of that decision, the court laid out, there's 4 different basic determinations. The first is they used the Herzog v. Herzog case decided by this court that says that the essential inquiry as to cohabitation is who is supporting whom and from what sources of income. In this case, we demonstrated that Deetra Butcher was living with Brian Acree, We demonstrated Deetra's income, which was at that time two sources, spousal support and her income from a job. We demonstrated her paramour, Brian Cree's sources of income, which were Social
But I
Security
thought
and
the
a
trial
pension.
court found that there was essentially a splitting of expenses, which would not be unlike a situation where people are just roommates. You move in and you're like, well, we'll split the rent, and you take electric, I'll take,
You're
cable.
correct, that is what the trial court found,
Right.
but that was against what the evidence was presented. Actually, the evidence that was presented showed that Brian Acree had paid the rent, which included water and trash. He paid the electricity. He took over those expenses on behalf of Deetra Butcher. And what the evening up that the court referred to had to do with food expenses that the parties had purchased.
What's wrong with that? Like, why can't I pay the rent and you pay the food if it's roughly equal?
Well, I don't think there's anything wrong with that, but I think you have to look at the totality of the circumstances in determining this. And as I indicated, this was just the first case that the court looked at in their analysis, which was who is supporting whom and from what sources of income. And that's what we presented, was showing that. The second issue came from Annenberg and as delineated by the state versus Williams, which talked about, had two separate essential elements for cohabitation. Number one, the sharing of familial or financial responsibilities and consortium.
And
Okay,
with regard to consortium, that's what you raised in the first assignment of error.
I did.
Okay.
And
Is consortium a finding of fact or or finding a law?
I think consortium is a finding of fact, and I think you have to look at the definition of consortium, which one, obvious definition is there an intimate physical relationship between the parties? But it's broader, and it was broadened by Annenberg, which talks about different things such as taking vacations together, working on familial relationships, holding family dinners.
So here's and this is only on the first assignment of error. As a finding of fact, then that would be reviewed under abuse of discretion, is that right?
Correct, yes.
So how would you direct us to get over that hurdle?
Well, I think for abuse of discretion, you have to look specifically at the party's daughter's testimony, Betsy Butcher. And she testified that she had lived with her mother for 6 months, from January of 2021 through, I believe it was May or June of 2021. She testified that during that time, it was a 2-bedroom apartment. She slept in one room, and she testified that her mother and Brian slept in the other bedroom, and there was one bed in that bedroom. So, as I said, there was only the determination that these parties were sleeping together in the same bed in terms of a physical, intimate relationship. Now, the daughters also testified as to some of the other issues of consortium, taking care of each other when they had illness. Brian Acree testified that he suffered from depression and that Deetra had helped him. She obviously had testified about her problems with cancer, all of the things that he did for her. And this was in addition to all of the other types of consortium that they testified to, taking vacations together, going to see Deetra's daughter a couple of times in Iowa when she was in college there. And so I think you have to look at the totality of all of that. And the way I actually look at this is in terms of cohabitation, what additional facts would be necessary beyond, over and above what we're given here in order to determine cohabitation? Each one of these conclusions of law in page 7, which was cited by the trial court, in terms of these are the kind of the roadmap that we're going to follow to figure this out. And there were facts to support each and every one of these factors. There weren't any that didn't, and that didn't apply. And so if you look at it, and like I said, I kind of
So I
looked
want
at
to
it.
make sure I understand. Are you, in essence, saying that that there's unrefuted facts and they only go towards cohabitation and consortium?
I think if you look at the totality of the facts, that's exactly correct. I don't think you can look at the totality of facts and say this doesn't rise to the level of consortium. You have two people who are sleeping in the same bed. You have two people who are vacationing together. You have two people who are holding family events for each other. You have two people who are taking care of each other. You have two people who are holding themselves out to the public.
Well, let me ask you about that, because the trial court specifically finds there is no form of intimate or romantic relationship between the two. And where were they held out to the general public or whoever as a couple?
There was a fundraiser that Brian Acree
Right, but
participated in.
that's the Facebook post where someone else said something, like,
Correct.
that's not, this is my girlfriend, this is my partner, like, that's someone posting something on Facebook.
In addition to that, Dietrich's daughter said she referred to Brian as her mother's boyfriend, that was her interpretation of their relationship, that's how she, characterized him. So I believe that, once again, that's the parties holding themselves out, and people outside of the two of them perceiving them as a couple, as in a relationship, people as close to them as Dietrich's daughter.
So you have about a minute left.
I'm sorry?
You have about a minute
Oh,
left.
thank you.
Okay.
The other conclusion of law that the court looked at was in the Mole case. That one talked about an actual living together, which both parties in this case, Dietrich and Brian, testified that they were living together of a sustained duration. By the time of the trial, they had been living together for approximately 25 months. And then with shared expenses regarding, with respect to financing and day-to-day incidental expenses. The expenses must amount to more than cost sharing. They must involve demonstrable financial support of the spousal support obligee. When Dietrich went from living on her own to living with Brian, her expenses were dramatically reduced. He actually did step into the shoes of the obligor by providing her with a place to live. He paid the rent. He paid, as I indicated, the utilities. And although the parties alleged that, we evened up the expenses, when we reviewed the bank records, there really wasn't any evidence of that. There was one small Post-it note where Dietrich had given Brian some money for some food at one point. But other than that, there was really no quote-unquote evening up.
Thank you. I'll reserve the remainder of your time, okay?
Thank you.
Thank you. Good morning again, Attorney Cook.
The key to this case is Annenberg, and Annenberg sets out one standard, was either party supporting the other. So was the person that's getting the support, using that support to support the person she's living with, or was the person she's living with using his money to support her? And that
Is
was
it
not-
just a financial question, or is there, like, care and?
There could be, however, that's just icing on the cake. So in Annenberg, those people held themselves out as a couple. They supported each other. He lost his job, and she paid for all the expenses after he lost his job. They bought luxury items together. The one who was making money, the man, bought luxury items for the woman. They were really clear. It was so clear. But in this case, it's so clear the opposite way. Now,
Well, your opposing counsel says that there wasn't evidence of actually splitting financial.
Not true.
Obviously, that's contrary to what the trial court found, but where would you point us to show us the evidence that there was splitting? And I also am not clear as to whether it requires like auditing perfection of 50%, 50%. I assume the answer is no, but how close does it have to be?
Okay, first of all, it's their burden, husband's burden
Sure.
to show this, okay? We presented bank records, and I've got the pages outlined in my brief, where we presented the bank records for both parties, Brian Acree and Dietrich Rocher. And they went through painstaking analysis in their testimony of how they did it. Brian was a cash guy. He takes out ATM money and spends it that on things. He uses his debit card. Dee Dee is a credit card person and auto pay person. And the auto pays that came out of Brian, this was his apartment. And he said, hey, you're having all these problems, you're having financial problems, you're gonna have surgery that's going to take up 7 weeks of recovery, and I can help you. Now, what happened was she moves into his apartment. He's already paying the rent, the utilities, all this stuff out of his auto pay. So she says, okay, I'll pay the cable and I'll pay the food. And she paid all the food. And we showed all the Kroger receipts. We showed how he wasn't going to Kroger. He was going to fast food places and $3 a pop when he would go out by himself. But she was the one paying for all the food. And we showed how this evened out over the years. Now, when they first got together, they were a little more careful. She would add it all up and write him a money order or a check. And as time went on, that wasn't necessary anymore.
And I guess like the question that this is also like begging in my mind is like, let's say they're both heterosexual, but they were instead they are in a same-sex roommate relationship. And one of them is struggling health-wise, financially. The roommate is a good friend, and the roommate is subsidizing that person for a period of time. I'm just trying to think about like that scenario versus this scenario, and what is the difference between them from this overall legal analysis?
Okay. Well, what I find interesting is I took a look last night to see if there had been anything since I wrote my brief. And there's a couple of cases, and kind of go to your point. And one of them talks about how the one party had helped the other out. And trying to decide which one it is. It is a case out of, called Husni, Husni, and it is from I think it's the 6th District. But in that case, 2023, Ohio 2175. That case was similar to what you're talking about. And there's no helping out here, is the problem. Look at the amounts they made. Brian is underwater every month with he's a Vietnam vet with PTSD and major depressive disorder. He gets a VA disability and he gets Social Security. And he's underwater every month until they move in together. She is about to be underwater because she's got this surgery coming up that she's going to be off work for 7 weeks. She has the time to take off work, but she can't support herself, and with just the spousal support and her $18,000 of income. Now, you can't ignore, when you talk about who has the burden here, you can't ignore the fact that John failed to pay her $96,000 of spousal support, Tier 2, over 5 years. He never notified her he got that money from the company. He never paid it. We discovered it when he filed this motion.
Understood. One of the things, and I'm going back to kind of like the first assignment of error and consortium.
Sure.
And I know that that's coming out of the Williams case, and,
Which has been rejected in Annenberg.
it can kind of go towards cohabitation, right? All right, so I'm looking again at the appellant's brief. One of the things it's stated in here is it goes to the daughter's testimony. And the daughter's testimony in that 6-month period that she resided with her mom. And
Please read the
what's-
transcript.
what it says there is that, that neither Deidre or Brian refuted Betsy's testimony. Can you address that?
Not true. It's the opposite. John didn't refute. She didn't even cross-examine Deidre on the testimony cross-examine Betsy on what I brought out, or redirect Betsy on what I brought out in cross-examination. First of all, they weren't living there. Betsy was living with Brian then because her mother was going to have the surgery, and Betsy's an alcoholic, and Betsy has mental health issues, really shouldn't be alone while Deidre's at work, so she's at Brian's.
I'm assuming this is part of the record, would you just say?
This is part of the record. So she's at Brian's. They think that's best for her to Mom thinks that's best for her to have somebody around. So she gives her the second bedroom. She sleeps on the couch when she comes to visit. And then when she has her surgery, Brian has an adjustable bed. She can't sit up by herself. Deidre's a big woman, and she had 112 stitches. So she couldn't sit up by herself, and so she takes the bed. Brian does sleep in there because he has to get up at night helping her. She's got 112 stitches. There's no intimacy going on, and it was only for the 7 weeks that she was having those problems.
So it
And
isn't
Betsy,
about. So,
I asked Betsy.
So what you're saying, it isn't about refuting the testimony, it's about giving information as to the why.
Yes.
Okay.
Yes. And there was no, when I asked her, that was only while your mom was sick, she said yes. And there was no question about that from the other side. So a couple things I wanted to comment on. The visits to Iowa. They took Betsy a car, my client's car to use, because she had car problems. And so they took her car and took two people, because my client was laying in the back seat of the car because she was still sick. And so Brian drove, and they gave her that car, and they fixed the other car. These things are.
Well, and I guess this gets back to my question earlier, which is, like, these things can be evidence of cohabitation. They could be evidence of a close, non-intimate relationship where one is supporting the other. And how do we sort that out?
The trial court sorted that out for you, because the trial court has the burden of determining the credibility of the witnesses and the testimony, and has the best opportunity to do that. The trial court did a very thorough job of doing that. The judge reviewed it and supported what the magistrate found. There was no intimate relationship. Yes, they dated in 2018 and found out it wasn't for either of them. Brian had just lost his wife. Deidre's son committed suicide during the divorce. It was a very, very sad situation, and she still hasn't gotten over it. His grandson, Jack, is somebody who reminds her of Zachary. And so she developed a kinship for this kid who plays football and did things like Zach did. And so she did become close to these people. I have friends that have stayed in my house after surgery because they don't have anybody else, who've broken their leg and stayed in my house because they don't have anybody else.
And do
That's
you
what
agree
these
that
people did.
consortium is a finding of fact? I assume you agree, because that's the advantage. But
Absolutely.
answer it as an officer of the court.
Yes, yes.
All right.
It is a finding of
Now,
fact.
cohabitation, is that a finding of fact or a conclusion of law?
That would be a conclusion of law after findings that warrant it.
Okay. And that's
And
sort of
by the
like,
way, I have no idea what an erroneous standard of
I understand.
review
I understand
is.
where that's coming from. Okay, yeah.
so,
Let me ask you, Ms. Cook, when I look at this cohabitation, I understand death, I understand remarriage, or cohabitation by wife in a marriage-like relationship. I mean, that can mean a great many things.
I
just
hate
depending
that
on the
standard, if you wanna know the truth.
Is that a standard used by the domestic relations court?
Yes.
I'm just asking. 'cause
Yes,
it could mean many different
unfortunately.
things, and proving it, you could prove it many different ways.
you can.
Depends on the relationship, right?
Right. It's not as common to use it anymore. Frankly, I wish I hadn't 10 years ago, in this case. But it's not as common to use it anymore, and we no longer make it with a unrelated male or unrelated female,
Right,
since we
yeah,
have all kinds of
yeah,
relationships now.
right.
But the fact is that these people were not in that relationship. I mean, they go on a cruise together because she wanted to get out of town for Thanksgiving because it really bothers her. And I've known this woman for 10 years. And so she said, I'm going to pay for this cruise. He said, well, I want to go on a cruise. So she puts it on her credit card, and there's part of the $100 a month that she owes him because she's paying for it. And they go on the cruise, and they do completely separate things. They don't even hang out together. So, everything that they claim was a fact gets refuted by the evidence. If the court doesn't have any more questions, I'm finished. But please look at my brief. I have all the pages marked.
Thank you.
Thank you. One of the conclusions of law that the trial court used was the recurrent theme in case law associated with this topic is that the spousal support obligee should not be permitted to reap the benefits of a relationship akin to marriage while the spouse support obligor remains financially liable for the maintenance of the support recipient. We would put forth in this case that's exactly what is happening and continues to happen. These people continue to live together in the same way that they have in the past. They've, if you will, checked off every box of the conclusions of law that the court found. This court asked, where is the testimony about Betsy Butcher indicating that she saw her mother and Brian sleeping in the same bed before her mother's illness in May of 2021. That's on pages 47 and 48 of the transcript. And if you read it, it's very clear. I mean, her mother didn't have any of the medical problems until May of 2021. Betsy testified she lived there beginning in January, and this is what she saw. But I agree with what the magistrate had indicated and the trial court had indicated, that the real crux of this situation is the financial support and what has happened. With Deetra Butcher, what happened was Brian took over her obligation to pay rent, her obligation to pay utilities.
Let me ask you this, ma'am. Didn't the magistrate find that some of this, whatever this relationship was fueled by your client's failure to abide by the court order and pay the $20,000 support? And, you know, she was owed $96,000. Didn't they find that this relationship, whatever it was, may have been fueled by his failure to follow the court order?
He did find that. However, the problem with that is there was a contempt finding, and Mr. Butcher did pay exactly what he was supposed to pay. The magistrate ordered him to pay it on a monthly basis. And what happened was this represented a 40% increase to Deetra Butcher's income. If the sole reason that she was living with another person was because she couldn't make ends meet, and all of a sudden she gets a 40% increase on her income per month, and yet she's still living.
Yeah, but she was
with
deprived of that
Mr.
money
Creed.
during the period of time when he should have been paying it.
She did, but as I said, the parties both believed that she was not entitled to it. This was something that went before the law. That's why in 2017, there was this determination, but
How did she believe she wasn't entitled to it?
she never sought it, she never asked for it, she
But
never
it's an
filed
S
anything.
corp distribution, it's not a public traded company. Like, how would she know about it unless there were some disclosures that were made?
Well, they both believed that when Mr. Butcher,
Objection, Your Honor.
There's no
There is no
objection.
basis.
There's no objection here. We will make our decision on the record.
I understand, Your Honor.
thank you.
Please, go for it.
Okay, thank you. As I indicated, Mr. Butcher had paid Mrs. Butcher $85,000 for her shares of the stock in the company at the time of the divorce. And he believed that he did not then owe her the S-corp distributions after that time. Obviously, he was incorrect, and the court found that, and he paid what he was obligated to pay. But as I indicated, that certainly, did not eliminate her additional income. As I said, now she has this money coming in. I understand that there are some bills, but she's still not obligated to pay her rent. She's still not obligated to pay her utilities because Brian is paying all of those things for her.
Thank you for your argument this
Thank
morning.
you. Appreciate it.
Okay. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. We wish you both a great afternoon, and since this is my last panel for the year, I hope you both enjoy your holidays and you have a wonderful new year, and I'll see you most likely in 2025.
Thank you.
All right.